Okay, so for the do now, hopefully you answered it by now. What rights do you have as an employee? Obviously, you have the right to make minimum wage. You have the right to get paid overtime if you work overtime. You have the right to be able to work in a safe working environment, have the tools necessary, all that kind of stuff. All right. So employee rights and responsibilities. Rights are that which belong to a person by law, nature, or tradition. Okay, so it's just the rights you have. Everybody knows what rights are. We talked about those in history and stuff like that. Responsibility, obligations to perform certain tasks and duties. All right, so obviously rights and responsibilities are different. Rights are what you have to be able to work. Those are what belong to you. Responsibilities are what you have to do. All right, statutory rights, rights based on specific laws and statutes passed by federal, state, and local governments. Okay, so that, like we talked about, are the laws that are given to you through the federal, state, local government. Okay, you can have some rights that the uh, employer gives you. You know, the right to free lunch. If you work so many hours, you have the right to, an hour break. You have the rights that employers can give you, and then you have the ones that are given to you by law. Equal employment opportunity. Everybody has to have the same opportunity to be able to get a job. Collective bargaining, which we'll talk about probably next week, is a union thing where they uh, negotiate contracts and things like that. And workplace safety, obviously, you have to be able to work in a safe work environment. All right, so contractual rights, those are the rights that are in your contract between the employee and employer, obviously. You have employment contract and agreement that formally outlines the details of employment. So those are going to be um, the laws that are written out, the whatever isn't that is in your contract. Then you have implied contract, the notion that a contract exists between employer and employee based on implied promises of the employer. So implied contract, all right, is when, you know, it's kind of like a word of mouth agreement, all right. This might be before um, this can happen before a contract. All right, this is kind of like if you say, okay, look, John, I'll do this for you, for $50. Then John gives you the $50. That's an implied contract. Now you have to complete the task. All right. It's the same thing with, if it was the other way around, and you have to cut the grass for $50. You cut the grass. The John agreed to it beforehand. Then he now owes you the $50. Okay. So there's things like that. Obviously, implied contracts get a little twisted, a little, problematic, I guess you could say, because it's kind of a word of mouth thing. But um, implied contract can still hold up. Okay, provisions in employment contract. So basically, you're going to have the parties in the contract, the duties, how much you're going to get paid, the terms and conditions of employment. So if it's employment at will or if it's going to be a contract year to year, termination, resignation factors, non-compete. I think we'll talk about non-compete down the road. Non-solicitation of current employees, blah, blah, blah. Okay, so there's in the contract, there's a bunch of different things just to protect the employer and the employee from if they leave or what is expected from them and, stuff like that. So, employment at will, okay? The employment at will means the employers have the right to hire, fire, demote, or promote as they choose. So that means that, if they don't think you're doing your job correctly, um, you the employer can fire you, promote you if you're doing well, whatever. Okay, it's not like um, it's not like a teacher who has a contract. Okay, if they have a contract until um, June, you know, from September to June, you're expected to be doing this job. So with the employer, employment will they can promote you, in the middle of in the middle of the year. they can fire you if you're not doing what you're supposed to be doing, okay? So just because they have the right to be able to fire you doesn't mean that they can just fire you out of nowhere, okay? They're still going to have to provide a reason, and if you have an issue with it, really provide backup, um, explaining why they had to fire you. Okay, the same thing with employees. They have the right to quit and get another job whenever they want. Also, okay, in the contract, and like say you have to work 2 weeks, or give your 2 weeks notice, but basically you can leave whenever you want, kind of deal. Uh, you don't have to finish out your contract. Now, if you have like I said, there's jobs like teachers where um, at my old school, where when I got the Manchester job, I wasn't able to just put in my 2 weeks notice and leave the next day, or leave whatever in 2 weeks, because I signed a contract that was different. I didn't have necessarily employment at will. I had to wait 2 months before I was able to leave. Okay, they had the right to hold me for 2 months. All right, so employment at will is a little different. I mean, it's not necessarily they're as a teacher and having a contract, and they'll be police officers are kind of the same way. Um, a lot of them are, at least a lot of union workers. It seems like this employment at will is kind of in their contract, but they're not necessarily following this. A lot of private companies employment at will. Okay, so employment at will restrictions is wrongful discharge and constructive discharge. Okay, wrongful discharge. Neither of these you're allowed to do, obviously. Wrongful discharge is termination of an individual's employment for an improper or illegal reason. Okay, so I can't fire you because I think you're ugly. I can't fire you because I think you're old. I can't fire you because um, you're, you are friends with people that I'm not friends with anymore. Things like that. Okay, you have to have a legitimate reason as to why you're being fired. Constructive discharge is an employer deliberately makes working conditions intolerable. So if I throw you in the, if I put you in an unsafe working condition, would kind of go under wrongful discharge. Or if I tell everybody in the office, okay, don't talk to this person, don't answer any of their emails, um, don't, you know, don't give them any work to do, anything like that, that would be constructive discharge. As the employer, I am making their life and their job impossible to complete, and um, giving them an unfair working condition that makes them have to quit. Okay, that's constructive discharge, also illegal. All right, so preparing a defense against wrongful discharge, there's a lot of written paperwork that goes into it. Um, Obviously, performance appraisals, written records, written warnings. So basically, if you have good reviews on all of your work and you know haven't gotten any warnings or haven't gotten in trouble at work, um, it makes the case a lot more difficult against firing. So they're going to have for a defense against wrongful discharge, you're going to have to show that this person wasn't doing what they were supposed to be doing. They've gotten the merits or whatever. Their performance reviews are bad, stuff like that. Group involvement, they can, you know, if they get like witnesses to say, oh yeah, this person wasn't doing their work, that kind of thing. Okay, so uh, we have just cause and due process. All right, just cause is for reasonable justification for taking an action. So you had a legitimate reason to fire someone. You had a legitimate reason to suspend somebody. Um, in the contract, they breached something in the contract kind of deal. You have a good reason. Due process is just that you went through the correct process in making your decision. Okay. So you went through all the steps. You talked to other workers. You looked at the contract. You you tried to make all um, you tried to give the employee all the help that they could in order to get this done, or you know, you talked to the employee separately a couple times before um, doing whatever the action is. Okay, it's just that you took all the necessary steps to be able to before you made this decision. It's just like um, when the principal gives you detention, or vice principal gives you detention, whatever. They went through all the steps. They talked to your old teachers. They asked what you were doing. They have a code of conduct, and if you are guilty of doing this, this is your punishment. Okay, you have due process. Then you have distributive justice, where the perceived fairness in the distribution of outcomes is fair. And then procedural is when the procedure is fair. Okay, so it kind of follows up the process. Um, so yes, it would seem like you know distributive justice, the outcome of it was fair. Yeah, that was the right decision. Or procedural justice was okay. The procedure was fair. So discrimination. Okay, we're going to talk about discrimination. Harassment. Discrimination is when you single somebody out. Okay, so that's like if I had everybody in the class and I said, all right, so all of the girls in the class, you are allowed to do this assignment. The guys, you're not allowed to, and you get a 0. Okay, you're singling out either a group of people or a person. If I was just like, okay, everybody gets to go on this field trip except for Bob, just because I don't like Bob. All right, that's discrimination. That's illegal. Harassment is just unwelcome conduct. So for example, if I was a teacher and always picked on somebody and they never knew the answer and I just kept picking on them, kept picking on them, kept picking on them, that would be harassment. Any unwelcome conduct. Or if someone says, "Please don't talk to me," and you just keep bothering them or sending them emails or something like that in an office, that would be harassment. Okay, that's also grounds for firing. So you have an assignment right here. You're just going to answer these 4 questions, turn it into the classroom.